Yeah, the chairperson is trying to log in. He should be in shortly.
So are you in for the duration of the whole meeting this time around, DM? Good morning to you.
Very, very good morning to you. Yes, indeed, indeed. I convey the greetings of your IEC National Political Liaison Committee representative.
Oh, yeah. Yeah, no, thank you very much. Yeah. This bill, I must tell you even before we start, it's got me very worried, but I will make my submission, but I am very worried.
Mm-hmm.
What occasioned it actually, as we were just chatting before the chair comes in?
Mm-hmm.
I mean, I'm just looking at all the priorities of the country. Why did this bill become even a priority?
Good
Well, I
morning,
don't know.
Honorable.
I mean, okay, I think the chair is calling us
Oh, okay.
to
Honorable
order,
Damas, good
but
morning.
I will address some of those matters
Okay.
in my input.
Okay.
I see you, Honorable Mani, and the DM are finding a way of conversing here. Members, good morning and welcome to the meeting. Good morning, DM and the team from the Department of Justice and Constitutional Development. Let me first apologize, colleagues, for being 2 minutes late. We are in the impeachment committee. Myself, Honorable Swart and Honorable Breitenbach. We are about now, as we speak, to vote for an evidence leader. And from there, we'll be dealing with the terms of reference which will determine and govern the work of the impeachment committee. So I wish to implore with you, members, and get your concurrence that we again today request as the committee Mr. Matafa to proceed with the meeting as we did yesterday. I am forwarding that request for your concurrence, members.
We concur, Chair, and convey our greeting to the impeachment committee and convey our concern that we're worried that they do one issue per meeting and that it's almost 3 months after the judgment, but the substance of the report has not even been dealt with. Please convey our concerns.
I will convey the Honorable Mani to the chair of the impeachment committee. Members, can we then allow Honorable Matafa to proceed with the meeting? I wish you well. I'm briefed that yesterday you proceeded very well. I will have to go back to the impeachment committee, unfortunately. Thank you so much, members, once more for allowing us not to be suffering as we did with the ADO committee. The ADO committee has made us stagnant and did almost nothing for the majority of the period of the existence of the ADO committee. And I wish that we don't suffer from the same fate as in relation to the impeachment committee. At least now it's only myself, Honorable Breitenbach and Honorable Swart, and our support team is not entirely affected as it was in the ADO committee. So we will have to find such kind of ways to ensure that the work of the committee proceeds simultaneously with the work of the impeachment committee, so that we don't suffer a serious backlog as we did. Members, thank you so much. Honorable Matava.
Thank you very much, Chairperson. Good morning to you, honorable members on the platform, the Deputy Minister, as well as colleagues and guests. Honorable members, we are gathered today in an ordinary committee meeting to reflect on the briefing by the department as far as the International Cooperation in Criminal Matters Amendment Bill is concerned. We'll also reflect on the responses by the department on the Judicial Matters Amendment Bill. Let me take this opportunity to welcome all to the meeting and maybe emphasize the importance of today's sitting. From reading the presentations and the correspondence that has been sent to us, it has come to light that the department seeks to modernize South Africa's framework for international cooperation in criminal matters by strengthening mutual legal assistance and through facilitating the use of audiovisual technology in judicial proceedings and enhancing cooperation with international entities investigating serious cross-border crimes. For us, these are important reforms at a time when organized crime, corruption, cybercrime, and illicit financial flows increasingly extend beyond national borders. I am encouraged that Honorable Manye has already picked up some areas of concern. And we are not worried that he says he's concerned, because we know that even when he raises his concerns, he's going to raise them in a constructive manner so that the committee is assisted in determining whether the bill is both constitutionally sound and practically implementable. So before I invite the Deputy Minister, let us note the apologies that we have received. We have received the apology from Honorable Minister Gubai, and we wish her well, as we know that she's not well. We have received the apology of Honorable Swart. Mr. Bonani, are there any further apologies that we might have received from your desk?
Good morning, Chair. Those are the only two apologies that we received.
Thank you very much, Mr. Bonani. Any other apologies from the call? With no other apologies, members, can I get concurrence that the agenda is fine, that we can proceed in this fashion? Can I please have a mover for the adoption?
I move for the adoption, Chair.
Thank you, Honorable Manyi. Seconder?
Chair, I second for the adoption of the agenda.
Thank you very much, Honorable Mutaung. The agenda being adopted, let me take this opportunity to invite the department through the Deputy Minister to lead us in introducing the bill. Deputy Minister, the floor is yours.
Chairperson and honorable members, thank you very much and very good morning to all. And thank you for the opportunity to present the International Cooperation in Criminal Matters Bill. I'm joined by Advocate Stephen Ralikwa, the Acting Deputy Director General for Legislative Development, and Advocate Tsietsi Sebelemecha, Chief Director, Legislative Development. They will take the committee through the detailed provisions of the bill, and therefore I'll confine myself to opening remarks on the broader policy significance and to explain why this legislation is important for South Africa's fight against crime and our constitutional commitment to the rule of law and our role within the international community. And I think, again, to make the point that we made yesterday, that in a year that we're celebrating the 30th anniversary of the adoption of the Constitution, it's important to recall that the Constitution commits South Africa to the values of human dignity, equality and freedom, but also that it establishes the rule of law as one of the founding values of our democratic order. And the rule of law means that no person is above the law, it also means that those responsible for the most serious crimes, whether committed within our borders or beyond them, should not be able to escape accountability simply because they cross national frontiers. Crime has become increasingly transnational. Organized criminal networks move people, money, weapons, drugs, and digital information across borders with unprecedented speed. Human trafficking, terrorism, cybercrime, money laundering, corruption, and the financing of organized crime increasingly involve multiple jurisdictions. Our response to these threats cannot stop at our borders. Just as criminals cooperate across borders, so too must those institutions responsible for enforcing the law. That's the broader context within which this bill should be understood. The bill modernizes legislation that was enacted almost 30 years ago. Without dating myself, I was there 30 years ago when we developed this legislation. It strengthens South Africa's legal framework for international judicial cooperation by providing clearer mechanisms for obtaining evidence, for enforcing lawful orders, for facilitating witness testimony, including through modern audiovisual technology, and executing sentences in cooperation with recognized international entities. So in a real sense, these are very practical reforms, but they're also important constitutional reforms because they strengthen the capacity of our criminal justice system to ensure that justice is not defeated by geography. The bill also reaffirms an important principle of South African foreign policy and constitutional democracy, and that is the fight against impunity. South Africa has consistently maintained that those responsible for genocide, crimes against humanity, war crimes, and other serious international crimes should be held accountable in accordance with international law. Because impunity undermines justice, it undermines peace, and it also undermines reconciliation. And ultimately, it undermines confidence in the international legal order. And so for that reason that South Africa has long supported the development of effective international institutions capable of ensuring accountability where national systems alone may be insufficient. In this regard, we wish to affirm government's commitment to the International Court of Justice and the International Criminal Court, and to the broader system of international criminal justice established under international law. The International Criminal Court remains an important institution in the global fight against impunity. Together with other international courts, tribunals, and accountability mechanisms established in accordance with international law, it contributes to ensuring that those responsible for the gravest crimes of concern to humanity are held accountable. And I think it's noteworthy that the International Criminal Court at the moment is facing an unprecedented range of attacks. Many of the judges of the International Criminal Court have been placed under sanctions by the United States. The prosecutors have been placed under restrictions and sanctions. And there are very open threats that have been made against the court. And South Africa, as one of the founding members or an active participant in the negotiation of the Rome Statute, one of the founding members of the Rome Statute on the International Criminal Court, I think has stood very, very firm in support of the court. And the bill, therefore, is part of a broader commitment to strengthening international cooperation in criminal matters and ensuring that South Africa has effective domestic legal framework through which it can discharge its international obligations. The bill itself is informed by the Rome Statute, and it aligns many of its procedures with mechanisms already found in that framework. At the same time, it's important to emphasize what this bill does not do. It does not diminish South Africa's sovereignty. It does not permit foreign or international bodies to operate outside our constitutional framework. On the contrary, every request for assistance is processed through African institutions. Ministerial oversight is maintained where required. South African judges and magistrates exercise judicial authority, and witnesses retain the protections afforded by South African law. Our constitutional guarantees of procedural fairness remain fully applicable, and the bill therefore strengthens international cooperation while preserving constitutional accountability. The bill also reflects another important reality. Modern justice systems must embrace modern technology. The provision for evidence by audiovisual link is entirely consistent with the developments already incorporated into our Criminal Procedure Act, and it reflects international best practice. It'll improve efficiency, reduce unnecessary costs and delays, and enable more effective cooperation in complex transnational investigations, while ensuring that the interests of justice remain paramount. Finally, Chairperson, this legislation is the product of careful consultation across government, including the Justice, Crime Prevention and Security Cluster, the Global and Continental Affairs Committee, and key institutions within the criminal justice system, including the National Prosecuting Authority. The bill represents measured, practical reform. It strengthens the fight against organized and international crime. It reinforces the rule of law, strengthens the fight against impunity, and it modernizes our criminal justice system. And it confirms South Africa's continuing commitment to responsible international cooperation in pursuit of justice. So, Chairperson, with those introductory remarks, through you, we would now like to invite the Advocate Ralekwa and Advocate Sibile Mecha to take the committee through the detailed provisions of the bill. Thank you.
Thank you, DM. Mr. Ralekwa can proceed if he's ready.
Good morning, Chair. I'm not certain if Mr. Ralekwa is connected as yet. It's Tsietsi Sibile Mecha. If you may permit that we can proceed, I would request our colleague, Advocate Takalani Ntanduleni, who has been leading the team that drafted the bill, to make a presentation, if you permit, Chair. Thank you.
It is in order, Mr. Sibile Mecha. Advocate Takalani can continue. Thank you.
Good morning, Chairperson. Good morning, DM. Good morning, honorable members, and thank you, Tsitsi, for this opportunity to make a presentation. Like Tsitsi indicated, my name is Takalani Ntanduleni. I'm the official from the Department of Justice who was responsible for drafting the bill. So I will start with the first slide of the presentation, which is the purpose. And obviously, the purpose of this presentation is to brief the Portfolio Committee on Justice on the International Cooperation in Criminal Matters Amendment Bill as introduced into Parliament last year. The next slide, please. The background, Chairperson, in 1995, the South African Law Reform Commission was mandated to investigate the problem associated with obtaining evidence from foreign states and international cooperation in criminal matters in general. So this led to the promulgation of the International Cooperation in Criminal Matters Act number 75 of 1996, meaning that the recommendations that were made by the South African Law Reform Commission was taken into the Act, which is now applicable. So the Act, as promulgated in 1996, facilitate judicial assistance in the form of the provision of evidence in criminal matters, as well as the execution of sentence in criminal matters. Chairperson, this act only applies to issues relating to criminal matters, not relating to civil matters. So the act as is now provide the cooperation and assistance only between the country and foreign states and not with entities. By entity, we mean that we mean the international organization, tribunals and courts, and all other similar bodies, excluding International Criminal Court established in terms of the ICCA Act. So the next slide is dealing with the problems relating to the current legislation, which is the ICCA Act. Like indicated previously in the previous slides, the Act as is now doesn't provide for judicial assistance to entities, meaning it only deals with foreign and states and the country. So that's a loophole that we're trying to address in the amendment bill. Also, South Africa is a member state to certain status, like the Rome Status and other charters, and at times we are required as a country to provide for judicial assistance. So the purpose of this amendment bill also is to ensure that we comply with the provision of the Rome Status. So also reliance had to be placed in our international obligation to assist other foreign states with regard to the provision for evidence. So the purpose of this amendment bill also will facilitate the compliance with the international obligation as indicated in the or provided in the Rome Status. So the other problem in the current legislation is that there's a need for clarity and certainty in our domestic legislation to cater for requests for judicial assistance. And like the DM indicated, that the other problem in the current legislation is that it doesn't provide for the giving of evidence by audio visual link. So that I will try to clarify that when we deal with the clause by clause in the next slide. So the next slide. Like I indicated, the current act provides for cooperation and assistance between the country and foreign states. It doesn't provide for assistance and cooperation between the country and international entities. So the purpose of the bill is to provide for that cooperation and assistance between the country and international bodies. And by international bodies, like I indicated in the previous slide, we mean the international organizations, the international tribunals, the international courts or similar body. But in the definition, we exclude the international court, the International Criminal Court that was established in terms of the ICCA Act. So in the nutshell is to also to ensure that the country complies or the legislature also comply with the international obligation. So if you go to the clause by clause in the next slide, you will see that we are inserting the new chapter 2A, which provides for the judicial assistance to international entities in obtaining evidence from witness in person in the country or for the execution of subpoena by South Africa in order to provide for the attendance of witness before an entity. So the purpose of chapter 2A is for two reasons. It's to provide for cooperation between the country and the international entities as they are omitted in the Principal Act. The second purpose is to provide for giving of evidence by audiovisual from a person present in the country. So these are the main purpose of chapter 2A, is just to address the gripe regarding the issue of international entities and also to allow people to give evidence through audiovisual. So in the bill, you see, Chairperson, we also try to clarify what do we mean by electronic virtual link, and it is defined to mean an electronic link between the court point and the remote point. So when you read the bill, we must also make reference to the definition of audiovisual link that clarify what we mean by audiovisual link. So also we in clause 3 of the bill, we again also insert another chapter 2A to provide cooperation with judicial assistance to entities, and it contains the following provision. These also are new provision that we are inserting in the Principal Act. So in the
Am I the only one without audio?
I've also lost audio.
Advocate Tagalani, can you hear us? We can't hear you.
Hello, Chairperson. Are you
Yes,
able to hear me?
proceed. Now we can hear you.
Okay. Chairperson, I was also trying to clarify. I was done with chapter 2A in clause 2, then now I'm in clause 3 of the bill, which we're also inserting chapter 2A to provide for cooperation with and judicial assistance to entities. Like I indicated initial, Chairperson, the Principal Act doesn't deal with the cooperation between the country and entities. So this is the main reason why we are also
Advocate Ndandureni,
Chairperson.
were you talking or were you just pausing? Because we can see
I
that
was-
your
I
mic
was
is
talking, maybe I'm
unmuted,
using-
but there's silence.
Can you give me a minute? Maybe I've got a network challenge in my office, so I'll go and join advocates for the match.
No problem.
Just
Thank
a
you.
minute. Just a minute.
Thank you.
Chairperson.
Yes, we can hear you, Mr. Sibele Major.
Yeah, it's Takarani. If I'm allowed to proceed in this office, Chairperson. So I was on chapter, the section of chapter 2A in clause 3 of the bill, and which is chapter 2A to provide for cooperation with and judicial assistance to entities and correct the following provision. Like I indicated, Chairperson, one of the loophole in the bill was in the act. Sorry, Chairperson, is the omission of cooperation between the country and international entities. So that's the main reason. And if you check clause 12A, we are provided for definition of the words that we are using in the bill. We have got the definition of entity that I earlier indicated that we are also defining that to include your international organization, the tribunal, the courts, and similar bodies, but we're including the ICC in that definition. So if you check clause 12A, we are dealing with a request by entity for assistance in obtaining evidence in the Republic. So if we that's the main reason for clause 12B. But if you check the content of the bill, you will see that we're also trying to clarify the process of obtaining the evidence by international entities in the country, and we also clarify the point of contact in the country to say that those requests must go to the DG. So and also just to mention that that provision, the new provision 12B, is also in line with the section 7 of the Principal Act, which provide for the same provision and provide for foreign request for assistance in obtaining evidence. And also just to indicate that the provision of that proposal in 12B is also in line with Article 15 of the Rome Statutes, which provide for the similar request. So if you go to the next clause, which is clause 12B, this deals with the examination of witness in order to obtain the evidence requested in terms of the previous clause that I indicated. So again, this section 12C or clause 12C is based on section 8 of the Act and Article 15 of the Rome Statutes. Like I indicated, Chairperson, the Principal Act deals with the cooperation between the country and foreign states. Then we don't have provision for international entities. So the clause in section 8 in the Principal Bill is also identical with this clause that we are inserting in terms of clause 12C. So if you go to clause 12D, that sets out the rights and privilege of each witness that will be required to give evidence to international entities. And again, the proposed clause 12D is also in line with Section 9 of the Act and Article 17 of the Rome Statutes. And what is important, Chairperson, to indicate in the meeting is that the provision relating to the rights and privilege also are in line with our own domestic legislation regarding privilege. So we try to align those provisions regarding the privilege that the witness have when they appear in court or to international entities. So moving on to clause 12E, which deals with the offense by persons who are called upon to give evidence. So that provision only relates to the offenses where the person were requested to come and provide evidence, but they failed to do that. So the purpose is to ensure compliance by creating an offense in order for witnesses to be able to assist international entities to provide evidence in the international entities or any court. So if we go to clause 12F, which is also a new provision, it talks about the attendance of a witness before any entity. So this proposal is in line with Section 11 of the Act and Article 19 of the Act. So the provision that we are proposing in the clause 12F are the same as those that are already in the Act in terms of Section 11 of the Act. So
No audio.
Advocate Ndanduleni, there's no audio on our side.
Chairperson, on a lighter and sillier note, I hope this doesn't undermine the point that is being made about audiovisual testimony.
I hope so too, DM. Can I request maybe advocate to try to find another location with a stable connection?
Chairperson, maybe you can indicate when did I get caught so that I can repeat again? If you may assist, Chairperson.
Before you change the slide.
Or before I change the slide, okay. So maybe you can go back to clause 12D, which sets out the rights and privilege of the witness. Is that fine, Chairperson? If I can start from there.
That's fine. Yes, please proceed.
Okay. So clause 12D sets out the rights and privilege of witness giving evidence. So I was trying to say that clause is also aligned to Section 9 of the Act and also Article 17 of the Rome Statutes. And also I indicated that those provisions we are also in line with our own domestic laws relating to privilege when witnesses give evidence in courts of law or international entities. So clause 12E dealing with offense by person who are called upon to give evidence. So the provision are also in line with Section 10 of the Act and also Article 18 of Rome Statutes. Here we're just assuring that the witness, if they are subpoenaed to give evidence, then they must be able to comply by creating an offense to say if you fail to comply with the subpoena, then it would be an offense in terms of the Act. So clause 12F, which provides for attendance of witness before an entity, this we are aligning it with the Section 11 of the Principal Act and Section 19 of the Rome Statutes, and also we're clarifying the process of transmission of subpoena from international entities to the country. And we are saying it must go to the DG, and the DG will process it further to the magistrate, to the relevant courts for requisition. So if you go to the next slide, which is clause 12 G, which dealing with the process of saving documents and process other than subpoena provided in the proposed clause 12F. So this also is the issue of the process of transmission of request in the country from international entity, and you are indicating in the bill that it must go to the DG for further processing. So clause 12H provide for the enforcement of any order issued by any entity against a person who has been served with a subpoena in terms of clause 12F, or a process or document in terms of the proposed section 12G in respect if which they fail to comply with. So this one provision, we don't have the similar provision in the Act and or in the Rome Statute, but for compliance sake, we have the view that we have to include this provision to ensure that the orders and subpoena issued by the entity are complied with. This is the issue of compliance, to say if they are issued, then there must be a compliance from the side of a person is expected to comply. So this is a new provision, but we are of the view that is necessary to ensure compliance. And if you go to clause 12I, it provides for the designation of the public as a state in which a prisoner sentenced by entity may serve his or her sentence. This person is found in the section in Article 31 and 32 of the Rome Statutes, and also the ICC Act. So the purpose here is just to make cross reference. We're just taking the provision as is in the Rome Statutes and the ICC Act to ensure that it also applicable to this act. So if you go to clause 4, the clause 4 in the next slide is to amend section 26 of the Act, which determines that a foreign restricted order needs to remain in place despite litigation being conducted. Currently, if we check the Act, Chairperson, you will see that the restraining order doesn't remain in place if there is a review or an appeal application. So we are changing that in the bill to say it will remain in place despite litigation being conducted. So the changes here is to repeal the words an appeal or a review in the principal act, and to say when it has been set aside, meaning that the mere act of appealing or reviewing that restraining order doesn't mean that it is set aside. So there must be a decision by court for it to be set aside. So if you go to clause 5, it amends section 27 of the Act, which allows the president to enter into agreement to provide for cooperation and judicial assistance to an entity or for the enforcement of any order or sentence, and may agree to any amendment of the agreement. So this is just an important provision in that to allow the president to enter into an agreement. And it's also, just to mention, Chairperson, this provision is in line with section 231 of the Constitution. And also other legislation, you see, like if we check the Establishment Act, it's also the empower the minister, rather the president to enter into agreement. So we're just taking that principle and take it to the SCCME, which is in the Constitution and other legislation that regulate the matters relating to this this cooperation. So if you check clause 6, it's just we setting you section 31A in order to allow any person who have been called upon to give evidence in terms of this act to apply for legal aid in terms of the Legal Aid South Africa Act 2014. So we know that the people can go to the legal aid and request assistance, but we're just emphasizing that if you have been called upon to give evidence, then you can also request that assistance through the Legal Aid Act for you to have legal representation when you appear to that in that international entities. So clause 7 deal with the amendment of long title of the Act. Chairperson, this proposal, because they're not in the Act, so there's a need for also align the Act with this new provision that we are proposing. So, and if you go to clause 8, is the issue relating to the short title and commencement. So the next slide, Chairperson, is the conclusion. We're just indicating the conclusion that the proposed changes are in line with the international trend in embracing advancement of technology. Like we indicated in the presentation, Chairperson, that we are making provision for the witness to give evidence through audio-visual link, and we're just indicating to say this is in line with the advancement of technology in the world. So, and also similar provision relating to audiovisual are found in the rules of procedure and evidence made under the Rome Statutes of the International Criminal Court Act 2000. So, Chairperson, proposed changes were made having regard to the extent of provision of the Criminal Procedure Act and the Rome Statutes, particularly with reference, if we check the issue of subpoena, that I indicated that they're in Section 8 of the ICCM Act, the Principal Act. Also, they're also in line with the Section 205 of the Criminal Procedure Act. So, thank you, Chairperson. That's the story from me. Thank you.
Thank you very much, Advocate. Members, that is the presentation. Can I note members who may wish to make comments, seek clarity, questions? I note the hands of Honorable Klopper, Mr. Manyi. At this point, those are the only two hands. Can I allow Mr. Klopper to come in?
Thank you, Mr. Chairperson, and thank you for the presentation. Greetings to the Deputy Minister. Chairperson, I do apologize. My signal was terrible, and between the loss on that side and my side, I might have missed something. So if I do repeat or ask something that has been explained, I do apologize. And we do recognize that what the bill's, the intent of the bill in the International Criminal Framework. The first question relates to Section 2H. If I understood, it permits a magistrate to issue a warrant of arrest and to order that person to be delivered into custody of that international entity. Does this recognize that this is comparable, and it's according to the LSSA, to surrender or extradition? And before such an order is made, will the person have an express right to legal representation, disclosure of the entity's request and order, and the opportunity to challenge the entity's jurisdiction and the validity of the order, the right to present evidence, and so forth? If these protections are intended to apply, why are they not expressly included in Section 12H? Sorry, it's just my glasses. Why does the proposed Chapter 2A contain no express grounds requiring the Director General, Minister, or the Magistrate to refuse, limit, or condition assistance where executing the request would conflict with the Constitution or fair trials? The prohibition against torture or cruel treatment, political prosecution. Will the Department support and express constitutional human rights refusal provision? And will written reasons be required where assistance is approved or refused? Chairperson, there is a clear distinction between the extradition bill requiring extradition inquiries to be conducted by designated magistrates with specialized training. The ICCM Amendment Bill never authorizes ordinary magistrates to determine privilege in disputes, endorse international subpoenas, issue warrants of arrest, and order delivery of persons into the custody of entities. Why was no equivalent designation and specialized training included in this bill? And will the Department support required appropriately trained magistrates for the exercise of power under Section 12D, 12F, and 12H? Chairperson, I will pause there and allow my colleagues also to have a bite.
Thank you very much, Honorable Klopper. Honorable Manyi.
Thank you, Chairperson. I think actually the questions by Honorable Klopper vindicate my concern. Chairperson, I must say at the outset, it is important that this committee approaches the International Cooperation in Criminal Matters Amendment Bill with a clear appreciation of what it seeks to achieve, and equally important, what it will change. Having considered the department's presentation, I am concerned that it presents the bill as largely a technical amendment intended simply to give effect to South Africa's international obligations. That characterization, I would contend, is wholly incomplete. The bill is not merely about improving international cooperation or modernizing procedures. It fundamentally expands the the jurisdictional reach of international entities into South Africa's domestic legal framework by creating mechanisms for the recognition and enforcement of their requests, subpoenas, and in certain instances, their orders. You know, Chair, as I was reading this thing, I just felt that this is international capture of the country. The background presented to the committee does not adequately acknowledge these profound constitutional implications. It creates the impression that the bill merely closes a legislative gap, whereas the real question before Parliament is whether these new powers are compatible with our constitutional order, the sovereignty of the Republic, and the rights of persons within South Africa. As a member of Parliament, as members of Parliament, our constitutional duty is not simply to facilitate the international cooperation. No. Our duty is first and foremost to safeguard the Constitution, protect South Africa's sovereignty, and ensure that no legislation delegates or diminishes constitutional authority without clear constitutional justification and appropriate safeguards. It is in this spirit, Chairperson, that I will be putting a number of questions, in fact, just 3. There were many, but I've reduced them to 3 to the department, particularly regarding the constitutional basis for these new enforcement powers, the role of the courts, the scope of presidential powers under the bill, and the extent to which Parliament is being asked to authorize the exercise of coercive powers on behalf of international entities. So I'm extremely concerned, Chairperson. This is just it's actually an understatement for me to say this. The first question that relates to the enforcement clause under 12H. The department has indicated that clause 12H, which provides for the enforcement of an entity's order against a non-compliant person, has no equivalent in either the current act or the Rome Statute. This is actually what's concerning, is that the presenter here, Tagalani, has been saying a whole lot of things as if the Rome Statute has been complied with throughout. Yet in the presentation itself, they make the point that it has no equivalent in either the current act or the Rome Statutes, but we are being presented as if all of this has been taken care of. I'm very concerned about actually misrepresentation. What is the constitutional and legal basis for conferring this new enforcement power, and what judicial safeguards, including prior judicial authorizations where applicable, judicial review and rights of appeal will be available before such an order is enforced against a person in the Republic? So some of the concerns of Honorable Topa are exactly the same as mine. On the second question, that deals with the sovereignty and the discretion to decline cooperation. In light of South Africa's experience, Chairperson, with requests arising from Rome Statute, including the Al-Bashir matter as an example, what discretion does the Republic retain under this bill to decline cooperation with an entity where compliance would conflict with South Africa's constitutional obligations, national security, or foreign policy? Can the department please identify the specific provision of the bill that expressly preserve such discretion? I want to hear exactly where does it provide for this discretion? The deputy minister's opening remarks did not give me any consolation, because it did not give us any citation. It was just talking broadly. Absolutely no citation, just talking broadly. No, this is good, this is okay, and all of this. Absolutely no citation. What can I get the citation of exactly where in the bill is this matter dealt with? This discretion dealt with, or we're going to get to a situation here where we're told that we want to do this and therefore must just comply. I'm very nervous about this. The last question, Chairperson, in terms of parliamentary oversight of cooperation agreements, Clause 5 amends Section 27 to empower the President to conclude and amend cooperation agreements with entities. The question is, what role, if any, does Parliament play in approving, scrutinizing, or reviewing these agreements before they are entered into force? And how does the department reconcile this provision with Section 231 of the Constitution governing the approval of international agreements? Chairperson, as I said, those are the three questions, but I have many, but I just thought these are the key ones. If the on an 80-20 principle, these three ones, if they are satisfactorily responded to, they will take care of the other 80. Thank you very much.
Thank you very much, Honorable Manyi. Can I check with members if whether there was still the last hand? In that case, before I allow the department to respond, let me ask Honorable Manyi just to lower his hand. Thank you. Let me also thank the presentation and welcome the opening remarks by the DM. I also just have a few observations and I'll just put them in questions. The first one is the point that Honorable Manyi is raising in terms of constitutional safeguards. So my question is very simple. What safeguards are we going to ensure that South Africa does not provide assistance where requests may undermine constitutional rights, especially fair trial guarantees? I think this is a very important point because as much as we have to observe international cooperation, we also need to protect our constitution. And that is, for us, important to find out what is the view of the ministry or the department if the committee were to request that there should be explicit constitutional and human rights safeguards in the bill that are exposed to indicate that we will assist, however, we are going to do it within the parameters of the Constitution of the Republic. And the second point is on the issue of the capacity of the justice system within the Republic. I believe the bill will place additional responsibilities on magistrates, probably Legal Aid South Africa, and the department itself. Has there been a detailed assessment done to determine if whether the courts have necessary infrastructure, the technology that is secure, that is adequate and able to be able to respond to such request and cooperation, and if whether the human capital is up to standard? And one last most important factor that we as Parliament play oversight on is the financial resources to ensure that these amendments are implemented effectively from day one. Speaking about oversight, how does the department envisage Parliament to play oversight on this agreement? Because the bill in its current form, and correctly so, empowers the executive to conclude cooperation agreements with these international entities. How would we then be able to play oversight over such agreements? Would there be a particular framework of reporting, a framework of oversight, and where necessary, intervention from the side of the legislature? And the last one from me, DM and the department and honorable members, we can speak with confidence that locally the asset forfeiture unit is doing wonders to recover criminal assets and to remove the benefit of crime. Now, the question would be, we are currently faced with serious challenges relating to organized crime, corruption, particularly illicit financial flows. Is there a way that this amendment will strengthen South Africa's ability to recover criminal proceedings or proceeds hidden outside of our borders? And if whether, will this amendment also contribute meaningfully to the ongoing efforts to combat organized criminal syndicates? If you follow what is happening and what is being reported on the news, the success of the police, South Africa has become a target by criminal syndicates. will this amendment be able to assist in strengthening our fight against such criminal activities? Let me welcome the DM and the department in responding and providing clarity on the points as raised by members. Honorable DM.
Chairperson, thank you very much. And thank you very, very much for members for, I think, very, very correct questions, because whatever we do does need to happen within the context of our constitution and the human rights guarantees in our constitution. We believe that this act and the broader concept of international cooperation is not in contradiction to the maintenance of those values and those rights. I think we also need to just bear in mind that, as the President stated in the State of the Nation address at the beginning of this year, that at the moment organized crime represents probably one of the greatest threats to our constitutional democracy. And we know that that international crime has a transnational dimension, and therefore it makes the strengthening of provisions for cooperation all the more important. Chair, I would ask that Advocates Ralikwa, Sibelemecha, and Ndandureni start off by answering, and I will then come back after they've replied. Thanks.
Thank you, DM and Honorable Chair and Honorable Members. I think maybe one thing that we might have omitted to indicate in the beginning is that this bill should be read and processed together with the extradition bill, because they complement each other. And the department has received already requests from the NPA broadly in respect of the ICCMA, some of the provisions that they would want to review in order to strengthen the fight against organized crime. And then the questions, I think I'll just some broadly try and respond to them. In terms of the rights when a person appears, those rights are still guaranteed, and as I indicate, the processing will be in line with what the Extradition Act or Bill currently will be providing for, where we're giving clarity in terms of the powers of the magistrates in relation to these matters. Then again, the issue, as indicated, I think there was an issue of the equivalent designated or specific designated magistrates in terms of what the Extradition Act says, or Bill, sorry, says, and why in this it is not properly set out as that. I think as we deal with these two bills, we can be able to reconcile the two, and if the language has to mirror each other, that we could possibly do under the deliberations that the Portfolio Committee will be having. And the issue of the processing of the cooperation still falls squarely within the Constitution in terms of Section 231. So these international agreements that are entered into from the executive side will then be following that procedure, wherein ultimately Parliament has got an oversight on these agreements, and the processing of them and the classification is fully done in terms of the Section 231. Therefore, Parliament still remains and retains the oversight that it has to play in terms of the Constitution. And indeed, we do not have to cooperate where the principles of cooperation are going to be against the Constitution. And I think the extradition bill as well clearly indicates that, for instance, if we take the Botswana Constitution, which is the opposite of us in terms of people who have committed crime, and do have the Constitutional Court judgment in respect of Tsebe, wherein if there's no guarantee, we will not be able to surrender or hand over the specific person. So those safeguards and the discretion still applies, guided by the constitutional principles that we have. And I think I would then maybe if I've dealt with the issue of the AFUD where the chair says they're doing well, but then how do we then enforce or reinforce them in terms of sufficiently dealing with the challenges that we have? As I indicate, there are still some of the provisions that they want to review in order to strengthen their capability. So this bill was more to align with what the extradition bill relates to, so that we're able to strengthen this international cooperation and the extradition aspects. If the colleague Takalani has got something to add, you will request this permission from the chair that he do so. Thank you. No, he indicates that is fine, is covered. Thank you.
Thank you.
Thank you very much. Then, so look, Chairperson and honourable members, I think the question of making explicit and where necessary in the bill to strengthen and make explicit our commitment to constitutional guarantees and human rights guarantees, I think that goes without saying. We are confident that those matters are catered for, but if members feel that we need a more explicit statement of those, I think that we can only support that. Chairperson, secondly, the questions that you pose, I think, are very, very important, and we can certainly follow up with a more detailed information to the committee. But I think just to say one, that certainly we would, through entities like the South African Judicial Education Institute, which we briefed the committee on yesterday, do the necessary training of those magistrates who are involved in this area of work. Secondly, the question of legal aid South Africa, as we indicated earlier in the year during the budget hearings, the Minister and I have been engaging with the Minister of Finance regarding the resourcing of legal aid South Africa. I think we have made very good progress on that front, and we would hopefully in the near future be able to report to the committee. But certainly more resources are under consideration for legal aid South Africa. Our court infrastructure in respect of digital infrastructure is something that we are putting a lot of focus on. And I think, again, the Minister has made the point that our priority at this stage is to get the underlying network infrastructure up to scratch. But I think at the same time, we must make the point that, especially since the COVID era, there has been a much greater reliance on virtual court processes, and certainly in the high courts, it's not uncommon for hearings, for trials to be heard on those platforms. Things like the introduction of the court online system have proceeded very, very well and have in many ways revolutionized the operation of our high courts. So we are confident that the audio visual testimonies envisaged in this legislation would be more than catered for in terms of the existing infrastructure. I think the questions regarding human capital and financial resources I've addressed partly, but certainly we can supplement that information and provide the committee with a more detailed assessment. I think just in conclusion to say that we guard our national sovereignty very, very jealously. And this legislation certainly does not contemplate in any way, and we believe that there are sufficient safeguards built into this legislation to protect our national sovereignty. I think also just to make the point, as we did in the beginning, that our national sovereignty is also, we also protect our national sovereignty by cooperating with other sovereign states in the common enemy to all of our sovereignty, and that is organized transnational crime and the violation of fundamental human rights, the perpetration of genocide and war crimes and crimes against humanity. Prosecuting those matters in cooperation with other states effectively strengthens the sovereignty of all states. Thank you.
Thank you very much, TM. The responses are highly welcome, and we appreciate the commitment that the points as raised by members will be considered and, where necessary, incorporated in the finalization of the bill. That is highly appreciated. Members, with those comments, can I then request that we move over to the next item, which is responses?
Chairperson, can I just do one quick follow-up? Just a closing comment from my side.
Not a problem. Please proceed, Honorable Manyi.
Yeah, no, Chair, I just want to put on record that for us as MK Party, we're actually very nervous about this. In fact, I think, just for the record, in the current formulation that has been presented, as MK Party, we reject this bill. We reject it on the basis that it actually, despite the minister's lyrics about safeguarding sovereignty, we've asked for specific references to the Constitution to buttress all their iterations, and there hasn't been any. So it's just a PR exercise. It's just talk. And we've asked a very simple thing. Go to the law. Tell us where exactly is our interest safeguarded. And none of that has just come. All we've just heard is a real corporate affairs exercise of no, everything is fine, we're looking after this, we're guarding sovereignty, all the nice talk. I'm not impressed, the Chairperson. I think the department must go back and be more granular about how their speak is backed up by specific clauses in the Constitution, Chairperson. I mean, even if you look at Section 231 of the Constitution, there must be specific which subsection is this bill going to respect, because there are certain executive discretions that are even allowed in Section 231. So, and there are certain sections in 231 that give Parliament the oversight. So that section that gives Parliament an oversight must be specifically referenced so that we don't get some other shortcuts at some point when you are in election mode, and then things just get sneaked in. So, Chairperson, I really don't want the department to go back thinking that they've had a good day here. It's not a good day, Chairperson. I'm very, very nervous about this. And as I say, for us as MK Party, with the current formulation, with no granularity, we reject it. Thank you.
Thank you very much, Honorable Manyi. Your inputs are noted. I am sure that the DM and the department are also noting them accordingly. And in the next interaction around the same bill, I believe that some of these concerns will be addressed. As the DM had committed that they are more than open to take into account the inputs that we make. But I see the DM's hand is up. Would you like to respond, DM?
No, Chairperson. I would just want to say that I would be equally concerned if the Honourable Manyi wasn't concerned. But on a serious note, I honestly don't think that there's much to be gained from trying to place ourselves at opposite ends of a commitment to seeing that the provisions of our Constitution are enshrined and safeguarded in any and every piece of legislation that we deal with. As I said, we believe that this legislation is consistent. It has been certified by the Chief State Law Advisor as being consistent with the Constitution. I don't think there's any fundamentally unconstitutional provision in this legislation. As we've indicated, we are more than happy, and I think Parliament would be failing in its duty if it didn't seek to make sure that those provisions are compliant, but also that in the interests of transparency and ease of understanding, that where necessary we make them more explicit. So I really don't see that this is a matter that should divide us. I think we need to pool our common energies to making sure that what might not be explicit is made more explicit. Thank you.
Thank you very much for your response, DM. With the remarks of the DM, can I then request the DM or the department to come back on the matter of responses by the department on the Judicial Matters Amendment Bill? DM?
Thank you very much, Chairperson. I'll be quite brief on this one because I think we have briefed the committee on it before, but really, I mean the key. I mean this is a judicial matters amendment bill. Again, the officials will take us through the detail. But the purpose of a judicial matters amendment bill, unlike other legislation that introduces new frameworks, is really to make sure that our legislation remains current, coherent, constitutionally compliant, and capable of supporting an effective justice system. We know that we need on an ongoing basis to refine our legislation, and I think this Judicial Matters Amendment Bill does address a number of quite important areas. I think the first is around the strengthening of judicial accountability. The amendments to the Judicial Service Commission Act expand the capacity of the Judicial Conduct Committee by enabling additional judges to be appointed where necessary to address backlogs, to deal with urgent complaints, and to ensure that disciplinary matters are finalized more expeditiously. That resonates very strongly with the concerns that have been expressed also by this committee in the past about undue delays in many of these processes. Judicial independence and judicial accountability indeed are not competing principles. They reinforce one another. An independent judiciary must also be a judiciary that is accountable through fair, credible, and efficient constitutional mechanisms. Secondly, the bill strengthens openness and transparency. Some of the amendments to the Promotion of Access to Information Act improve access to information, simplify administrative arrangements, and give effect to the Constitutional Court's judgment in Arena Holdings versus SARS concerning access to tax records in circumstances where disclosures demonstrably in the public interest. The third is that the bill strengthens our fight against corruption. It closes a number of technical gaps in the Prevention and Combating of Corrupt Activities Act by ensuring that appropriate penalties apply to the offence of failing to prevent corruption within private entities and state-owned companies. And this gives further effect to the reforms arising from the recommendations of the State Capture Commission, and it reinforces our broader anti-corruption agenda. The fourth objective is to promote a more humane and developmental child justice system. The amendments ensure that children who are alleged to have committed cannabis-related offences are dealt with through the child justice framework, rather than unnecessary arrest, and thereby it aligns our legislation with our general approach to the dealing of children. I think another significant area is that the Legal Practice Act. The proposed amendments seek to modernize aspects of the legal profession and remove unnecessary barriers and improve access to legal services. Among other reforms, the bill provides for automatic right of appearance for legal practitioners in all courts. It rationalizes provisions relating to practical vocational training. It expands opportunities for legal practice within public institutions, and it improves the functioning of Legal Aid South Africa and other public legal services. I think those amendments really support a broader transformation agenda within the legal profession, whilst at the same time promoting access to justice. So I think lastly, Chair, it also modernizes our legislative response to cybercrime. I think as criminal activity increasingly migrates to the digital environment, our law enforcement framework must evolve accordingly. The proposed amendments clarify the investigative powers and improve the legal framework governing cybercrime investigations whilst preserving appropriate safeguards. So taken together, these amendments demonstrate that maintaining the rule of law requires continuous legislative adaptation to changing social, technological, and constitutional realities. We also want to emphasize the quality of the parliamentary process that has brought us to this point. The department has carefully considered the submissions received from stakeholders, including Judges Matter, the Information Regulator, the Legal Practice Council, the Law Society of South Africa, the Banking Association, SARS, and members of the public. And where persuasive proposals have strengthened the bill, the department has recommended amendments accordingly. And I think this just underscores the importance of public participation in our legislative process. So, Chair, with that, I would ask then that Advocates Ralekwa and Sibile Mecha take us through the department's responses. Thanks.
Thank you, DM.
Thank you, Chair and DM and honorable members. I'll be doing the presentation on the responses. I think we could go to slide 4, because slide 2 is the purpose, 3 is commentators that the DM has already covered. If you can go to slide 4, and also request that it be put on the slide mode, presentation mode, sorry. To slide 4. And the next one, yes, thank you. We've done the table in terms of the submissions or comments in the way of referencing to the clause that the comment refers to, and we have captured the essence of the comment and the department's response, and whether in view of the department's assessment, we proposing any amendments to the specific clause arising out of the comments that have been made. And in respect of clause 1, which essentially deals with the section 8 of Act 9 of 1994, the Judges Matter have made a submission that there could be a greater guidance that is given in terms of the JCC chairperson's Judicial Conduct Committee chairperson discretion to appoint additional judges when dealing with unavailability of permanent Judicial Conduct Committee members or backlogs, as it is contemplated in clause 1. And such guidance will then include that the JCC chairperson should prioritize the appointment of the retired judges or to serve as additional members of the JCC. And in response thereto, we are saying this is for us not a matter that requires clarity or amendment to the JSC Act. It's something that could be done because the chair is permitted to appoint whoever those are members of the JCC. And in respect of the comment number 2 about the retired judges will be better suited to discharge the objectives of the intended amendment as they have the skills and the time. I think that goes along with the same, the one above that says the Act does not necessarily prevent the retired judges from being members of the JCC. The chairperson has got the discretion to appoint whoever basically that may assist in order to deal with the complaints and the backlogs in an expeditious manner. If we go to the next slide, the clause 2, the amendment, the comment comes from the Banking Association of South Africa, BASA, wherein they say we should consider establishing the compliance requirement based on the size and the public or the small private bodies in relation to a phased implementation approach to allow these organizations to make provision for the solution in their budget. This is because a number of the public and small private bodies may lack the technical capability or the infrastructure to maintain electronic records or hyperlinks. This is a risk, they say there's a risk of non-compliance due to technical or resource constraints. And comment number 2 as well, they are saying they're supporting the support in terms of this amendment will be required from the information regulator. And in response, we're saying we have conducted research and also consulted with the information regulator because this emanates from their side as well as information regulator. And the view then is held that the public bodies and the private bodies, as they are defined in the PAIA, they have got the necessary infrastructure to ensure that their manuals also contain the website link to the latest notice regarding the records as proposed in this clause. So we have not foreseen, or we do not foresee any challenges, and we've done consultation with the information regulator in this regard. Still on clause 2, Mr. Robert Mailula also made a comment to say public bodies must continue to make physical information available despite the amendments that we're making in there, for example, in the municipal buildings, community halls and schools, especially in rural areas. The ones who are saying we're agreeing that the latest notice will be made available physically. So we are not saying if information is put up on the website, the physical availability of the records or manuals should be done away with. And we do not suggest any or propose any amendments to clause 2. Next slide. This one deals with clause 6, which amends section 46 of Act 2 of 2000. The BASA's comment is saying the amendment should also clarify the criterion and establish a clear process in determining when a public interest justifies the accessing of tax records. And the response is that section 46 of PAIA already provides for mandatory disclosure of records in the public interest and provides for the circumstances in which the public bodies may grant access to the records that have been requested in the public interest. And section 46 clearly determines the criteria in respect of when the disclosure of records is in the public interest. In this regard, PAIA provides that the public interest in the disclosure of the record must clearly outweigh the harm contemplated in the provision in question. And we are not proposing any or suggesting any amendment to the clause. Next slide. Dealing with clause 7, the BASA again comments that section 34A appears to introduce a form of strict liability for failure to prevent corruption with a possible defense if adequate procedures were in place. However, PRECA currently provides no definition or guidance on what constitutes such procedures. And then saying providing such guidance will provide clarity sought by the entities. A clear definition of or reference to an existing legal definition is essential to ensure certainty and consistent application. And in response there, we're saying the clause provides a penalty which the previous amendment omitted. So basically just doing a technical linkage because when we're inserting the clause, we had not referenced it as a penalty. Then the intention of the amendment is just to prevent corruption within private and state-owned entities. The amendment arose out of the Zondo Commission recommendations, and we believe that adequate procedures is not defined, as this is based on an individual entities and what is applicable to them. Then again, the BASA was saying a clarity is sought regarding whether a member in Section 34A refers solely to a natural persons, e.g. directors, officers, or employees, or it also includes the legal entity, and whether the offense is aimed exclusively at corporate entities, as well as whether it extends liability to individuals with those entities itself. Therefore, clarity will ensure that the amendments are enforceable, fair, and effective while they providing legal certainty to both the private and public bodies. And as we indicate in our response, the Section 34A of the Prevention and Combating of Corrupt Activities Act also applies to individual members of private sector and incorporated state-owned entities. And we are not proposing any amendment in line with the comments received. Next slide. This comment relates to clause 8 to 13. Mr. Robert Mailula has indicated that the amendment must also emphasize the diversion programs, counseling, and sport-based interventions as alternatives to formal sentencing, and as well that the municipalities should be mandated to partner with local sport clubs and youth programs to implement the diversion programs effectively, and this will then prevent criminalization of youth and promote reform through support, especially in under-resourced rural communities. We've noted the comment, and we are then saying in response, the diversion of the children away from the formal criminal justice system is regulated already in the Child Justice Act 2008. And so there is no need for us to add more provisions in relation to the amendment we are doing. Mainly, we are with these proposals, we are just making sure that those children that are found in conflict with the law in relation to cannabis, also they are properly dealt with in terms of the Child Justice Act. Next slide. Therefore, I'm not proposing any amendment. Next slide. The clause 15, this deals with the Legal Practice Act, and BASA has made a comment that the clause may potentially expose courts and clients to unsupervised or insufficiently qualified representation. The oversight or sign-off from a previous principal or designated legal LPC-approved mentor may be required and beneficial in this regard. And this, you members and the chair may recall that this talks to the automatic right of appearance, and the proposed amendments to Section 25 of the Legal Practice Act, they emanate from the LPC and LSSA, and this seeks to provide for the automatic right of appearance in any court in the Republic for legal practitioners. Its intention is to, if it is approved, the consequences that any attorney can immediately after admission appear in any court to undo the unequal provision that exists that only advocates can do so. There are attorneys who have since been admitted but do not have the right to appear in the High Court. In order to place these attorneys at par with the attorneys who will be admitted after commencement of this Section 25, the previously admitted attorneys are granted automatic right of appearance upon commencement of the Act, and while those who will be admitted afterwards will have the automatic right from the date of admission. This position is the same as that which applies to advocates, and there is no rationale to retain the distinction between advocate and attorneys as it comes to right of appearance, which retains the ideas of the divided profession. This has been found to be unconstitutional in a recent judgment, which we're dealing with of Ramalepe. It is now going for constitutional confirmation, which is still to be, as I indicate, we have got the judgment. We've already made our responses to the confirmation proceedings. Therefore, we are not proposing any amendment based on the comment. Next slide. Still on clause 15, the Law Society of South Africa has made a suggestion that for eligibility of legal practitioner who is not enrolled as a practicing legal practitioner to acquire an automatic right on appearance contradicts section 24 and 30, and that the objects of the proposal as it is contradictory in its own context, then a legal practitioner who is not practicing is not enrolled to practice and is only enrolled on the non-practicing role and therefore cannot appear before any court. The words "or not" must be removed from the proposed session. I think this is just to clarify that the interpretation of the clause then says all people who are admitted as legal practitioners, whether you're non-practicing or not, and I think that is not basically the intention. And we then agree with the proposal by the LSSA, and that we should then link that right to the status of the practitioner as a practicing legal practitioner. And we have then also consulted with the LPC regarding this position, and we have then come up with a proposal that, in line with the LSSA submission, clause 15A and B, it has been revised. Sorry, it's supposed to be 15B, has been revised to then read: a legal practitioner who was admitted and enrolled to practice as such before the amendment of this section automatically acquires the right to appear in any court in the Republic upon the commencement of this section. So we believe this proposal will then deal with the issue of excluding those who are enrolled as non-legal practitioners. And on number 2, the proposed on the comment, the proposed extension must be able to allow a candidate to elect to apply for an extension of a minimum period of 6 months. This deals with the candidate attorneys, or a maximum period of 12 months. And the proposed proviso in the clause to the amendment is, in the view of LSSA, unreasonable, as it is prescriptive and is not considerate to those who find themselves in the unconducive, potentially abusive environments which may be at play under whom the candidate legal practitioner is registered. And we then say, as a response, we have consulted with the Legal Practice Council with regard to the comment, and the LPC is in full agreement with this position by the LSSA, and therefore the department supports the proposal to extend the provision by 6
Audio is gone.
Chair, am I the only person who's not hearing Advocate Sibele Mecha?
It
No,
seems that
you're
it's all of
on the
us.
dark.
Maybe still struggling with the network.
I will quickly go and check in as to whether is it network or what.
Thank you.
The next meeting must be physical.
No, Honorable Mani.
Yeah, no, Chair, I'm back. Sorry, I just got cut. Are you able to hear me, Honorable Chair?
It's fine. Proceed. We can hear you now.
Yeah, today we seem to be having a bit of challenges. We can move to the next slide, wherein we want to this proposal that we have will be that a candidate attorney who is entitled to appear as contemplated in subsection 5 will remain so entitled to appear at the expiry of the practical vocational training, but not for longer than 12 months until that candidate attorney is admitted as an attorney, provided that such candidate attorney remains in the employ of the attorney who was a principal to that candidate attorney immediately before such expiry. So this is the proposal that is to cater for the extension of the period. And then the other comments basically that are here still relate to the same area in regards to the extension of the candidate legal practitioner. So the proposal is to resolve it by the amendment that we are saying we can revise the provision in order to grant that extension. If we may move to the next slide. The provision still continues. in that the first option was that the candidate remains in the employ of that first legal practitioner. And the second option is that they remain in the service of a legal aid South Africa, a legal aid office or other institution that is approved by the council, consent, as the case may be. Then in paragraph B, then it says a people who has completed the practical vocational training remains so entitled to appear at the expiry of the practical vocational training, but not for longer than 12 months until that people is admitted as an advocate, provided that such people remains under the supervision of the training supervisor of such people. This just deals as well with the two, whether a person seeks to admission as an attorney or advocate. If we may move to the next slide. Mr. Robert Mailula also had a proposal that the proposed changes to expand the training venue, simplify appearance rights, and enable more people to complete vocational training are highly welcomed. It's just in agreement with the proposal. Next slide. Then moving on to clause 16, that deals with section 26 of the Legal Practice Act. BASA made a comment that the current 4 or 5 year requirement ensures comprehensive coverage of core legal principles, practical skills, and professional ethics. Removing the duration of 4-year constraints may potentially encourage establishment of diploma mills offering quick LLB qualifications. This relates to the legal qualifications that is required for one to be admitted. And currently, the Act talks to LLB qualification. And this then we have looked at, because there are those that basically we're saying we do not agree with the comment by BASA. The amendment is intended that those who seek to provide that the person to be admitted must satisfy all the requirements of an LLB degree obtained at any higher education institution as defined in the Higher Education Act, which offers LLB degree registered in terms of SAQA. This being the case, it is not necessarily spelling out the duration of the LLB as section 26(1)(a) of the Act does, at the request of the South African Law Deans Association. The references to the length of study in paragraph A1 and A2 of section 26 of the Act are therefore deleted, because some people will necessarily do more than 5 years, but still meeting the requirements of the qualification of LLB. The SALDA points out that as section 26(1)(a)(2) currently reads, it appears as if the LPC must approve a 5-year degree, which is incorrect and could not have been in the intention of the legislature. The Council for Higher Education accredits degrees having regard to the national qualification standards, and therefore the LPC has a broad role regarding standards of legal education, but no accreditation powers. And therefore the standard content and duration of the LLB curriculum is considered by different role players as a matter of course, but cannot be determined by the Act. And the next slide. The next slide, please. Yes, thank you. We're now dealing with clause 19 in terms of section 28 of the Legal Practice Act. The South African Revenue Services made a comment that the recognition of SARS as a form of legal practice in order to allow their legal practitioners to practice as attorneys and advocates is requested. And Chair and honorable members might recall that by the time we made the briefing to the Portfolio Committee, we had mentioned that SARS approached us after when we had already submitted the bill for certification post-approval by Cabinet. And the department in response was saying, I'm just indicating that we had made that indication that SARS has approached us, and we had consulted with the LPC regarding the SARS request, and they are in support of the proposal. The LPC indicated that SARS, I think we lost the slides. Chair, am I audible still?
Yes, you are. The presentation is off the screen.
Yes, I'll just talk to my colleague to just check if they can reflight that.
Thank you. Please proceed to do that. Ntate Sibile,
Yes, Chair. Tabsil is just sharing again. We
okay, I see
can go
that the
to.
screen is about to share. I would have
Thank you.
wanted to check with the members because these presentations we receive upfront. So I wanted to check with members if whether would have been proper that we consider the presentations as having been read, so that maybe even if it cuts off, you may still proceed to speak to salient issues in the presentation. But since the presentation is back, you may proceed and let's see how long will it be able to hold on.
But I agree with you,
Yes,
Chair.
thank you. Yes, thank you, honorable members and Chair. I will proceed in the event.
Thank you, Honorable Manyi.
Yeah, so I was just indicating that the LPC, we consulted them and then they've indicated that SARS should be aware or be conscientized that they will be subjected to the code of conduct and other regulation that is applicable to the form of legal practice. That this was just to make sure that they are aware that not only will the legal practitioners within the SARS who are going to be permitted be only dealt with in terms of the code of conduct of the SARS, but also the legal practice, because they'll then be practicing legal practitioners and no longer non-legal practicing members. And therefore, following that, the proposal is that we can add the certain amendments to the bill in order to define South African Revenue Services as referencing to them. I think there's just an error there in terms of the number of the act. We will correct it to 1997. And as well that we'll then have to amend section 34 by the addition in subsection 5 of the following paragraph. If you can go to the next slide. That we're going to add paragraph F that will then say, as an attorney employed as a member of the Special Investigating Unit or as an official of the South African Revenue Service, because we're already adding the SIU officials. And as well, I will add then in subsection 6, the following paragraph E, to say, as an advocate employed as a member of a Special Investigating Unit or an official of the South African Revenue Service. So this will then enable those that will be permitted to practice properly admitted as practicing legal practitioners within SARS. And these are more within the specialized courts, not necessarily throughout the courts. And they'll be dealing only with matters that pertain to their employers. And then another proposal would then be to amend section 84, wherein will then be substituting the preceding words in subsection 1 with the following words to say, every attorney or advocate referred to in section 34(2)(b, other than a legal practitioner in the full-time employ of the South African Human Rights Commission, the Commission for Gender Equality, or any other state institution referred to in Chapter 9 of the Constitution as approved by the Minister by notice in the Gazette, the Special Investigating Unit, the South African Revenue Service, or the state as a state attorney. So this will then be just complementing the reference to all those that are permitted to practice whilst either in the law clinics of the South African Human Rights Commission, the Commission for Gender Equality, or within any other Chapter 9 institution. Furthermore, amendments will then be required to subsection 9 to say no legal practitioner in the full-time employ of the South African Human Rights Commission, Commission for Gender Equality, or any other state institution referred in Chapter 9 of the Constitution as approved by the Minister, by notice in the Gazette, the SIU, the SARS, or the state as a state attorney, state law advisor, or in any other professional capacity may receive or keep money or property belonging to any person except during the course of employment of such legal practitioner with the state or the South African Human Rights Commission. Basically, the subsection being long is just referencing to the issue of those that are not permitted to just exclusion of the non-practicing legal practitioners, that they cannot keep any monies belonging to other persons. Next slide. Then we're moving to clause 20, that we received a comment from BASA that says the law clinics that are handling matters without fidelity fund coverage, even without trust funds, may expose clients to uncompensated losses in the event of misrepresentation, negligence, or fraud. They propose that some form of coverage is still applicable to maintain the integrity of the profession. And the response were indicating that legal practitioners who practice as a part of a law clinic do not manage trust accounts. Therefore, it is not necessary for those legal practitioners to possess a fidelity fund certificate, because they'll be practicing in the account, basically representing the employers. And in the cases that they deal with, do not necessarily relate to, the clients necessarily, but within the scope of work of that the employer, referencing, for example, to Human Rights Commission, the Commission for Gender Equality. And if there are any issues relating to the fees or costs that are recovered, they necessarily are dealt with within the rules or the procedures relating to the recovery of fees for that would have been incurred in them dealing with those matters. Clause 21, the BASA again still says the broader inclusion of non-SAPS officials could lead to, this deals with, just background, deals with the definition of a police official in the Cyber Crimes Act, wherein, as members and Honorable Chair will remember, that we are expanding the definition to include those that might be, for example, environmental inspectors, in order to seize some articles that might be required as evidence by those that may be found with certain articles that contain elements or evidence relating to a commission of a crime. And then the concern is that if we include people who are non-SAPS officials, then we could lead to jurisdictional confusion and coordination failure, especially where parallel agencies act without clarity. Again, they're saying the amendment should be accompanied by comprehensive regulation detailing coordination procedures, supported by the memorandum of understanding between relevant agencies where that is relevant. And for example, establish a clear jurisdictional hierarchy defining primary and secondary investigative responsibility, implement binding interagency coordination requirements, and also define offense categories, sectors and assign responsibility to those that may be granted this power. And in response, we're saying the administrative procedures relating to the handling of criminal investigation and arrest still apply in relation to the implementation of this clause. The intention is to address the unidentified capacity gaps in cyber crimes investigations by including officials who are authorized to investigate crime in terms of other legislation. And this could be municipal police officers, traffic officers, border guards, etc. And I've also mentioned the issues of the environmental inspectors to also enforce the Cyber Crimes Act. The coordination procedures which are already in place will apply in relation to the implementation of this proposal. Next slide. The Mr. Mailula as well says that clear safeguarding the regulations that protect the rights of young people, activists, and community journalists is recommended. Maybe, Chair, just to mention, the department is currently drafting regulations on cyber crimes, and we have been consulting with the SAPS. They have then raised a slight amendment that we might have to to add in the definition of the police official, and the recommendation, if we look at the bill, which will properly indicate to the members when you do the deliberations, is that we should remove the word access, because if we say the non-SAPS, if I can use the word, borrow the word, those that we're extending to, they can search, access and seize, then it means access. It might allow them to download the information, and once they download the information, that might border on tampering with evidence in terms of the cyber crimes. And when those that are permitted to and would have acquired a warrant to go and download, then the compromise of the evidence might come into play. So they were recommending that we remove the word access, but will properly, because this came after we had prepared, it came in our meeting on Monday. So we'll then properly request the portfolio committee as during the deliberations and point out the actual proposed amendment. The next slide. Yes, generally, then there are certain comments which were not specific to certain clauses that we have captured from judges' matter, that the amendments will not achieve the intended outcomes overall without the attention being paid to other capacity constraints. This relates to the JCC issues, which severely limits the effectiveness of the Judicial Conduct Committee and the judicial misconduct system generally. And further, that the capacity constraints include the inadequate numbers of staff that is available to assist the JSC as the secretariat, which provide administrative, secretariat, and research support to both the JCC and judicial conduct tribunals. Again, that there should be more thoroughgoing legislative reform to the JSC Act, and possibly a standalone bill that will regulate judicial misconduct generally, including a streamlined process, clarity on the roles of the different stakeholders, that is the CJ and the JSC, and proper institutional infrastructure for investigations. Next slide. And again, that in the submission, the
Audio is lost, and that is very much. Advocate Nandu, are you able to assist? We cannot.
Chairperson, yeah, I will check in.
Thank you.
Yeah, sorry, Chair, we are back. I don't know, today it's just difficult. Am I audible, Chair?
Now, even on my side, it's saying my network is unstable.
Where are you?
No, I'm in Pretoria CBD, Chair.
Yeah. Okay.
Yeah, I think. Sorry, we're trying to connect the second gadget so that in the event we go off. So I was just indicating, Chair, that by the time we're processing the bill, there were already proposals that they wanted us to add, but then they were still processing them. And we had thought we could not delay the bill because we had to deal with other issues. So in support of what the judges matter are saying, that there's a need for a broader review, that is indeed the case, such is in progress. So we'll, at the appropriate moment when they've finalized doing their assessment, will then provide us with the amendments that we will then bring to Parliament in the next legislative program also. Next slide. And then the submissions that we received from the information regulator, was to indicate that in order to cure the identified lacuna that the regulator can bring a criminal charge in terms of Section 77K for non-compliance with an enforcement notice, but the information officer still fails to release the record within 180 days as required. Then the following amendment is proposed to Section 78A of the Provision of PAIA. Is proposed by the addition of 78.5, which could read as follows. When the period of 180 days has lapsed and no application has been brought to court for appropriate relief in terms of Section 78.2, Section 78.3, or Section 78.4 of the Information Regulator, may then release the record to the requester. Then our view in regard is that we support the proposal, and we further suggest that the addition of to the proposed amendment be as follows. Then we'll then have to insert a provision that amends Section 78 of PAIA, as it was amended previously by the Section 28 of 2013 of Act 42 of 2013, and as well substituted by Section 110 of Act 4 of 2013. By saying this follows, there will be the clause that we insert to say Section 78 of PAIA is hereby amended by the addition of the following subsection. Then we insert sub 5, which then reads that when the period of 180 days contemplated in Section 78 and no application has been brought to court for appropriate relief in terms of Section 78.2, 3, and 4, the information regulator may release the record to the requester. This is in line with what has been proposed by the information regulator, and with the permission of the portfolio committee, will then insert that into the current bill. The next slide. Mr. Mailula as well has made a general comment that municipalities should be mandated to partner with local sport clubs. This was a repetition, basically, that programs to implement the diversion programs should effectively prevent criminalization of youth, and as well that he recommends that community legal clinics, school outreach programs, I think I've already captured this, and that we've just noted it, but the diversion programs, as I indicated, are dealt with adequately in the Child Justice Act. The next slide. I think that is the end, Chair, and we then submit those proposals that we've made and will be properly guided in terms of the deliberations of the portfolio committee. Thank you. And apologies for the network. I think today is just a bad day for us on the network side. Thank you.
No, it's understandable. Thank you for the presentation. We are also struggling this side because even for me, it keeps on throwing a notice that my network is not stable. But I'm happy that at least we are able to get this far. Members, that is the presentation. Can I note members who may wish to engage? And Tade Wanani, please help me with hands if I cannot see all of them. I see Honorable Mani, I see Honorable Klopper. Any other hands? Let's start with Honorable Mani.
Yeah, thank you, Chairperson. I just want to maybe just comment on how the department has responded to these public comments. I think the department has responded to every submission it received, but the quality of those responses has been uneven. In many instances, it says noted. The department, or it would then say the department does not agree, or it would say this matter is not a matter for this bill, without either engaging deeply with the substance of the concern or even making the undertaking to refer it to where it's supposed to be if it's not for this bill. We want to make the point, Chair, that the purpose of the presentation is to respond to public comments. For us as Parliament, we take public comments very seriously because they help us as Parliament in terms of where we're blindsided, as it were. So therefore, we would want a situation where when the department engages with public comments, it must really do justice to everything. We want to argue that noted is not an answer. disagreement is not a substitute for reasoned justification. So, Chairperson, we've made a couple of observations so that they get clear feedback as a department. That where the department did justice, for instance, it accepted several technical submissions from the Law Society of South Africa and consulted the Legal Practice Council, resulting in amendments to Clause 15 on rights of appearance and practical vocational training, 10 out of 10. It accepted the information regulators' proposals to amend Section 78 of PAIA and propose wording to implement it, 10 out of 10. It also supported SARS' proposals to recognize SARS legal practitioners within the Legal Practice Council, subject to the committee's agreement, and drafted consequential amendment. See, those were very substantive responses. But where the responses were weak, firstly, on the BASA's request for guidance on what constitutes adequate procedures to prevent corruption, the department merely says it cannot define the concept because it depends on each entity. It offers no legislative guidance or regulatory framework. So we'd want the department to redo that response to BASA and address it just like it addressed the ones I've mentioned above. Substantively, deal with the matter properly. On cybercrime enforcement, BASA requested detailed coordination mechanism between agencies. The department simply replies that existing procedures will apply without explaining why they are sufficient. So we really want BASA to be taken seriously. On judges' matters, broader concerns about judicial misconduct capacity, the department merely notes the comments and says it will review the Judicial Services Commission Act in due course without committing to any timeline ready now. So, Chairperson, let me conclude by saying, indeed, the department has done a reasonable job in addressing drafting issues and technical amendments, especially where stakeholders identified inconsistencies. However, on broader policy concerns and requests for greater safeguards or clearer legal standards, many responses are cursory in nature and do not fully engage with the underlying issues. And we would want to call on the department to take each and every stakeholder as if it's the only stakeholder they have and address matters deeply and substantively. So on all the areas where I've indicated here that the responses have been weak, we would call on the department to redo those responses, or rather answers, in a manner that is substantive. Don't do this noted cursory thing, we don't agree, and stuff like that. All stakeholders must really be treated with the respect they deserve. Thank you, Chair.
Thank you very much, Honorable Manyi. I think maybe let me underscore the 2 points that Honorable Manyi is raising. The first one is where the response is noted. We believe that it's important that the committee is taken into the confidence of the department. When a point is said to be noted, does it mean that it's acceptable? Will it be incorporated? Or it is noted for future consideration? So that one for us, it's very important. It may not necessarily be for this meeting, but it is important that when the final deliberations happens, we are at least aware which are those particular considerations emanate from the areas where it was said it was noted. And the reason I'm rising on this one is again linked to the point that Honorable Manyi is raising about judges' matter. They support the bill, but continue to argue that legislative amendments alone will not resolve the issues of backlogs, unless, of course, the Judicial Conduct Committee and its secretariat are properly capacitated. Now, the question that will beg from there is if whether, outside of the amendments, has the department considered concrete administrative or budgetary interventions in pursuit to strengthen the judicial misconduct system? And again, like in the previous presentation, for the committee, it is important to understand how the fiscus will be impacted in any bill, in any amendment that is before it. So it is very much important to get a comment from the department as far as that is concerned. We are quite comfortable with the response by the department on the SARS legal practitioners issue. The question that maybe I have is has the department considered whether other specialized state institutions may seek similar recognition in future? And if so, how would those particular requests, if they come, would they be processed outside of this process that we are currently engaged in? Maybe just the last one, it's on the matter of access to information on PAIA. Now, the department contends that the public and private bodies already have sufficient infrastructure to comply with proposed electronic publication requirements. It would be helpful if we know what is the view, or if whether there was sufficient assessment done to support this particular assertion, particularly when you consider smaller municipalities and rural public institutions. Do we have evidence to back that position, that there is sufficiency as far as private and public institutions are concerned? Before I allow the department, I think I had noted Honorable Klopa. Am I correct?
You did. Thank you.
Yeah, my apologies for undercutting you. I would have wanted to come after you. But please do proceed, Honorable Klopa. And yeah, those will be my questions. And then after that, the department can come through. Honorable Klopa, my apologies. Please come through.
No problems at all, Chair. Thank you very much. I will keep it short. I just have a question on clause 21 on expanding the cybercrime powers beyond SAPS. The department has said that it can include municipal police officers, traffic officers, border controls. I'm not sure if it's limited to that. So I would want to know if we would be able to be provided with a list of officials and legislation under which these powers will be extended, of the police officials' powers under clause 21. I would like to also get clarity. Does clause 21 mean that traffic officers, municipal police officers, border guards, and other officials will be able to do independently to arrest people? Would they need warrantless? Would they be able to do searches without warrants, access electronic devices, or seize data under Chapter 4? Or will they only be permitted to be assisting SAPS? And then on that, what additional training or compulsory training in cyber crime investigation, digital evidence, privacy rights, lawful search and seizure must these officials then complete before exercising these powers? Chairperson, where will the training be required, if there are indeed, but given that Section 55 of the Cybercrimes Act specifically places training obligations on the Minister of Police in relation to SAPS members? Chairperson, excuse me. Then I'll just ask a question or two on clause 15, the automatic appearance rights in every court. And Chairperson, I just want to know what evidence has the Legal Practice Council provided that admission as a legal practitioner without further superior court experience or assessment is sufficient preparation to appear in every court, including the Supreme Courts of Appeal and the Constitutional Court? And why has the department chosen an entirely automatic right instead of a competency-based system that would apply equally to attorney and advocates? And what protection will exist for clients specifically who may unknowingly instruct a newly admitted practitioner with no experience in superior court litigation? And Chairperson, my last question, it's more just for clarity. I just maybe don't understand. Is it so? And if it is, why should a candidate practitioner lose extended right of appearance merely because they move to another LPC-approved principal or institution, particularly when they leave a unsuitable working environment? Could the right follow the candidate subject to continued supervision and LPC approval? And Chairperson, that will be my last question.
Thank you very much, Honorable Klopa. Honorable DM and the team, those are the comments from members. Can I give it back to you, DM,
Yeah.
to at least assist us with responding and delegation to the department? Thank you.
Chairperson, no, thank you very much. I would propose that the department starts and I will conclude.
That's in order. Thank you, DM.
Thank you, Chairperson and DM. Just to, maybe we do accept the issue that in future will then, or even during the deliberations, will then expand further on what noted would mean, and where we disagree and perhaps there is no proper reasoning, will then expatiate that. The issue, I've given example, for example, to the issue of the JSC amendments, that the OCJ has been doing a review. By the time we're processing the bill, they then requested that we hold on to it, but the process was already in such a way that would not have been able to process it. And remember that this bill comes from the 2024 legislative program, although introduced in the 2025. So we then will be coming back with what will be extensive amendments to the JSE Act to extensively deal with this issue. So by the time we deliberate, we'll come back with the process and the status of the review, and will indicate to the committee in terms of how far they've gone in terms of doing that review that we'll need to then look at. And the issue with regard to whether the assessment, if we look at the issue of SARS, for example, and any other specialized or specialized entities or so, will then be assessed. I think we do that in terms of as and when we are approached. But if the committee may look at what the bill already has been proposed, the Human Rights Commission was permitted. Then the Commission for Gender Equality made a request. We have then expanded the provision to include all the Chapter 9 institutions. So that assessment we've done in respect of that. But then in respect of the specialized entities, we would want to do an exercise outside so that we don't grant a general permission without having properly satisfied ourselves. For example, the SIU, we know they go to the tribunal. They will not go to any other court.
We have lost you in your responses. Please try your audio again. And that is Sibele Meja. Can you hear me? DM, I see you are coming.
No, Chair, if we could maybe just reach out to Advocate Sibele Mecha, and in the ultimate case, we can get him, if there's someone online who can phone him, and then just direct the phone through the system here.
That will assist. If someone can intervene, we'll appreciate it. Thank you, DM.
Chair and Deputy Minister, I'm just going down to the office. I'm trying to phone them, but they're not answering. So I'm just going down to the offices quickly.
Thank you.
Thank you.
Yeah, Chairperson,
Honorable Chair.
Yes, we can hear you. Please proceed.
Yes, apologies. Yeah, just switching off the volume on the other gadget. I was just giving example that SIU, SARS go to specialized courts, and then when we deal with any other entity, we would want to have that comfort as to where they're going to be appearing, and also properly consult with the LPC, because we do not want to perhaps at this point just open up for everyone, and then as well remembering that those who are within government are necessarily not permitted to practice, because we've got the Office of the State Attorney. So we'd also not want to negate the purpose of why do we have a state attorney and the coordination of litigation matters within government. Just on the question of PAIA, I'll leave it to Advocate Ndanduleni. I think there's something that, as we're assessing the question, we picked up slightly. You'll come on that one. It's just verifying one aspect. Then the issue around the bodies that are listed in the definition of police official relates to those that we have mentioned, just examples. For example, the proposal was received, and mostly the practical example will be those of environmental inspectors, who will be wherein they would not be able to call on the assistance of a police official, because they'll mostly operate in the remote, in the forests and whatever, but then are confronted with a person who has got evidence and in front of them can simply destroy an article that contains evidence. And therefore, this seeks to empower them. In terms of their law, they must firstly be authorized to be conducting a specific work. So the power would not extend to the powers beyond that which your legislation that you'll be exercising your functions ordinarily grants you that specific power to do certain things. So we'll then, for example, if we look at municipal police officials, the question will be, in terms of the powers that will be exercising, whatever function that will be conducting, if, for example, they're confronted with a situation where there's a commission of evidence and the article, in the same example that I've given to environmental affairs, environmental inspectors, they will be able to seize. And with the caveat that I've made, that when you're consulting on cyber crimes, the SAPS has then raised the issue of removal of the word access, because that will then empower them to download. And the downloading of information then requires you to have a specific warrant to download. So we'll then request the portfolio committee to consider the removal of the word access, so that we then do away with that possibility. And currently, we've had discussions, yes, in terms of the practicality of how this should be done, and between the environmental officials and the SAPS, for example, then that protocol that those exist in terms of how they do work, and the police officials are the only ones in terms of the investigation of crimes within the broader criminal justice system, will be the ones that this non-police officials that we're extending the powers to cannot go beyond the issue of search and seizure in respect of that, and then they'll have to hand over to the responsible police officials that will be able to further deal with the issues in relation to the Cyber Crimes Act. And the list is not exhaustive. It's just, we're just mentioning in terms of who may be authorized, but the authorization firstly should come from a specific act that authorizes you to perform a specific function. And so there will be certain of the police, maybe traffic, if I give the example, the traffic wardens as an example, they've got limited powers. So in the course of event, perhaps there's a roadblock, and which will be conducted with the police presence, and they are busy doing the inspection in terms of the vehicle, and then they see an article that will contain evidence. There and then, ordinarily, they will have to call a police official because the presence of the police official is there. They would not act on their own, but where they find themselves, they are alone and they can prevent the further commission of a crime. They should act in terms of search and seizure and then hand over to the relevant police official. I think my colleague, Takalani Tanduleni, will then deal with the aspect of the PAIA, the clarification we need to make. And then if I miss something else, he'll also assist. And sorry, the other one on admission, where we open it up. And currently, and Law Society, I think, has made that example clearly to say, if I recall correctly, to say, currently the distinction is not even evidenced by what happens between the 3-year period of the difference between the advocates and the attorneys. It's simply a period and there is nothing that happens in between. So the training that is received by people who get admitted as attorneys and those who get admitted as advocates is the same, comes from the same, training from the universities. So there is not necessarily a difference in that if an advocate is admitted today and an attorney is admitted today, why then an advocate will go and appear in certain higher courts after having done their practical vocational training? What then is the difference that we're treating attorneys differently? I think that was raised as a serious concern in respect of this. And the Ramalepe judgment that I'm referring to has specifically identified that. But by the time they took us to court, we had already, with the LPC and LSSA, identified this inequality. And the court in the High Court has then confirmed, even despite having said we've got a bill before Parliament that seeks to address the concern, they've then indicated that the section is indeed unconstitutional. So we're just waiting for a constitutional confirmation, but the bill is already before the Portfolio Committee. And as having emanated out of the concerns that were raised by the Law Society and the LPC, that we should not treat the advocates and attorneys differently without a concrete difference between the two in terms of the training and the like. I think my colleague Advocate Danduleni, if it's permitted, will then clarify the one aspect and also deal with the questions that I might have missed. Thank you.
Chairperson, may I proceed?
Please do. Thank you.
Chairperson, the issue of PAIA, I just want to mention that Section 14(1)(b) that we're amending in this bill is only applicable to public bodies, not private bodies. And the purpose of the amendment is to ensure that the manual that must be made automatically available to public contain the website link to the latest notice regarding the records as proposed in the clause. So what we did as a department, we consulted the information regulator based on the purpose of this amendment, not on the comments that we received from PASA relating to private bodies and the small public bodies. So what we'll do is that we'll go back to the information regulator and get the inputs regarding the comments that we received from PASA before the Portfolio Committee consider or deliberate on the provision of the proposed clause in the bill. Thank you, Chairperson.
Thank you very much, Advocate Ndandureni. DM, any?
Yeah.
No,
Chairperson, thank you very much for both your interventions and those by members. I think at the outset, just to say that we are in absolute agreement that given the importance of public participation, that each and every submission that is made must be dealt with seriously, with due consideration, and be responded to fully. I think there's no doubt about that. And I think the department has given the undertaking that it would do so. Secondly, there are a number of matters that have arisen through public participation, which point to the need for broader, more fundamental and long-term reforms in various aspects. And I think those have been noted, taken very noted, and as the department has indicated, some of those matters are already being attended to through broader legislative development projects by the department. I think it's important to also remind ourselves about the general purpose of a Judicial Matters Amendment Bill, and that is to attend to some very, very specific matters emanating from either court judgments or proposals by relevant stakeholders or other matters of an urgent nature. It wouldn't necessarily be appropriate to try and deal with those more fundamental reforms through by way of a Judicial Matters Amendment Bill. And I think, Chair, that also links to the very important issue that you've raised around the need to bear in mind both the fiscal as well as the institutional and human resource implications of some of these amendments. I think lastly, Chairperson, maybe just in thanking all members, we would like to assume that the number of 10 out of 10s that the Honourable Manye has given the department, and the fact that he has indicated that the responses have been reasonable, we hope that on that basis we can at least on the Judicial Matters Amendment Bill lay claim to having a good day before the Portfolio Committee. Thank you.
Thank you very much, DM, for the closing remarks. Members, can I note that the responses were sufficient? No follow-up? Are we all covered? Thank you very much, Honorable Manye. DM, let me once again thank you and the team for the presentations and engagement on the matter. We are really looking forward to the final deliberations, and we appreciate all the efforts that were placed in making today a success. That would be the conclusion of the last item on the agenda, members and guests. Let me take the opportunity to thank all on the call, members, DM and the department, guests and the support team, and wish you well for the day as we come close to the meeting. The meeting is adjourned. The next meeting will be communicated through the normal platforms. Thank you very much, and I wish you a lovely day further.
Thank you, Chair. Thank you, DM.
Thank you very, very much, Chairperson and members.
Recording stopped.